Hello. Hi, good afternoon, seniors. My name is Fatah Mahama. I'm a Part 1 student in UPSA Group C. Can anyone confirm if they can hear me, please?
Yes, we can hear you, senior.
Telfer, Senior Telfer, please, can you hear me?
Yes, please, I can hear you. Good afternoon. Hi, can anyone hear me, please?
Yes, we can.
You can be heard.
Great. We shall make a start shortly. Just give me 1 minute. Fata, do you want to make some comments before we proceed, or I can proceed?
I was speaking earlier, but I don't know if you guys heard me.
Yes.
So good afternoon, seniors. I beg your pardon.
I think you broke off along the line, so you may just go again.
Okay, sorry. So my name is Fatah Mahama, Part 1 student in UPSA Group C. This has been put together by a few friends and myself as our way of making modest contributions to your academic journey. As we have indicated, it's going to run from now until you take your final examinations, and we hope it can support your studies in one way or the other. So thank you for joining the session, and Telfa will take it from here.
Right. Thank you, Fatah, and good afternoon, everyone. Thank you for joining.
Good afternoon.
Thank you for joining today's tutorial discussion on the law of interpretation. Today we'll be looking at a very interesting topic, repeals and retrospective legislation. That is what we'll spend the bulk of our time doing. As usual, if at any point in time during the discussion you have a question, you can simply use the hands up feature here available on Meet, and then I would call out to you. So as much as possible, please keep your microphones on mute so you do not disrupt the entirety of the class. If there's something I've said that you do not understand, or you'd require me to clarify, or you want to share your thoughts, please feel free to express same by virtue of using the raised hand up feature. Having said that, we'll make a start, and let me share this with you. One second, please. Can anyone please confirm if they can see my screen?
Yes, we
Yes.
can.
Great. Today we are looking at repeals and retrospective legislation or retroactive legislation. And I want you to keep this in mind because it's a question I'll be asking in a few minutes. Whether there's any difference between the word retrospective and retroactive. You'd find that oftentimes there's a difference. I mean, the word retrospective and retroactive is used interchangeably, and it appears as though some of our legal scholars have suggested that they mean one and the same thing. So we'll see whether they mean the same thing as we go along. But generally, our focus is on repeals and retroactive legislation. This is an offshoot of statutory interpretation. So, like I mentioned to you, and if you've had the opportunity to look at or view our earlier sessions, I think right at the beginning, I mentioned to you that you need to understand interpretation in this way. Interpretation is basically three basic blocks, and everything falls under these three main basic blocks. There's non-statutory interpretation, which relates to the interpretation of non-statutory documents such as wills, contracts, and other documents that you'd be required to interpret the meaning of the words used in that document. And there are the rules that relate to non-statutory documents, as have been set out in the case of binding and binding, and supplemented by the decisions, for instance, in Monta Patterson and Simmons, and those other line of cases. So the binding and binding 3+1 form the rules of non-statutory interpretation. And then there's statutory interpretation, where words will be used in an enactment, i.e., an act of parliament or subsidiary legislation, and you'll be called on to interpret the meaning of those words because the word attracts multiple different meanings and is capable of several different interpretations. And so, to that effect, you, as the judge, if you like, will be called on to evince the true meaning of a word used in a statute. And when it comes to statutory interpretation, apart from the basic rules of statutory interpretation, there are those other elements that we look at. For instance, the canons of interpretation, the aids to interpretation, presumptions, all of those elements or those sub-themes are vital in understanding statutory interpretation. One of such sub-themes is what is known as repeals and retroactive legislation. And so when an enactment has been repealed, what is the effect in law? When an enactment is of a retroactive or it is retrospective in nature, what is the effect in law? The focus of what we are going to be doing this afternoon is to look at the position of the Interpretation Act and our 1992 Constitution as it relates to the concept of repeals and retrospective or retroactive legislation. And the goal is to ensure that at the end of this discussion, you have a thorough understanding of what the legal effect of the repeal of an enactment is, such that when you are faced with a set of facts where a law is being, or there's an attempt to apply a law that has been repealed, or there's an attempt to apply a law that is of retrospective application, you can be able to point that out and identify what the true legal effect of that is. And so that is the position and that's the framework within which we are going to operate this afternoon. Is there any question? I think I had somebody's mic on, but because I'm in full screen, please hold on. Great. So let's begin with repeals. What does it mean to repeal an act or an enactment? Now, to repeal an act or a portion of that act or enactment, what you have essentially done is to ensure that that act or a part of that act ceases to be part of the body of law. And so, just like um, Article 106 of the 92 Constitution vests power in the Parliament to make law by virtue of Article 93(2), which ensures that Parliament is the legislative entity, such that in terms of our three arms of government, legislative power is vested in the Parliament, and that power is regulated in accordance with Article 106. And so, to that extent, when Parliament is making law, they must of necessity comply with the provisions in Article 106. That power to make law also implies that when Parliament has determined that after a point in time, that law is of no legal effect, or that law does not, if you like, achieve the purpose for which it was set out, Parliament has the power to, in a subsequent legislation or in a subsequent action, repeal the law. So the repeal of that statute or the repeal of that provision of law is the process by which Parliament cancels, suspends, or annuls the operation of a provision of law. And when that happens, that particular provision or that particular law is considered null and void to the extent of its repeal. And so what would happen is that going forward, any application of that law would be unlawful. Consequently, you would find that in many enactments, there are provisions or there's a specific provision for repeals. So if you look at the Companies Act, for instance, it has repeals. The Land Act 2020 has a section on repeals. And so when there's a newer act, that is, if you like, revising the position of the law in respect of a subject matter, you'll recognize that there's a provision that outlines or that indicates that the certain particular provisions of law or certain enactments have been totally repealed. And that is the point of the repeal process. In terms of repeals, there are two main ways in which repeals can take effect. There's an express repeal, there's an implied repeal, and another way in which repeals may take effect is what is known as sunset clauses or sunset provisions. We'll talk about that shortly. But the first one relates to express repeals, where an express action is taken by the Parliament to revoke the application of the law. So, for instance, when Act 992 was enacted, Act 179, which was the law in force at the time relating to the regulation of companies in Ghana, was repealed and replaced with Act 992. That is an express repeal, where when you go to the text of another legislation, you would find that it is explicit in there that a particular provision or the entirety of a law has been repealed to the extent that a new law has come into force. And so a repeal may be such that it entirely replaces the old law, it modifies it in some bit, or it limits the extent of its application. What you would see in an express repeal is that when you take the legislation or the newer legislation, you would find an express provision to that effect that a repeal has taken place. That is what is known as an express repeal. An Interpretation Act provides for express repeals. So if you look at Section 32, it indicates that where in an enactment it is declared that the whole or part of the enactment is to cease to have effect, the other enactment shall be deemed to be repealed, to the extent to which is so declared to cease to have effect. And so Section 32 of Act 792 is in effect a confirmation or an affirmation of the power that Parliament has to do away with the application of a certain statute at any point in time. And that's when Parliament has expressly indicated that the whole or part of that statute is to cease to have effect, to the extent that that is provided for in the newer legislation, then it will be deemed that that old enactment will be deemed to have been repealed. And so express repeals are fairly straightforward. On the other hand, there are implied repeals. Implied repeals operate when a newer statute conflicts with an older one without expressly providing for a situation where the statute expressly indicates that it is amending or repealing the former statute. And in that instance, there becomes a contest as to what should be the application. So, for instance, you may have a situation where a law is enacted in 1971, another law is enacted in 1992. The 1992 law did not provide for an express repeal of the provisions in the 1971 law. But to the extent of the 1992's inconsistency with the 71 one, based on a Latin principle or a Latin maxim which is known as legis posterioris, it will indicate that a law that is latter in time should be made to supersede a law that is former in time. And so implied repeals relate to situations where we have two conflicting laws, each having their own regime in terms of application, but both being inconsistent with each other. How do we resolve this inconsistency? There are two principles that have been developed by the courts in respect of dealing with this inconsistency, and then we'll look at them at some point, which is the legis posterioris and the generalia specialibus non derogant principle. These are all instances that help the court to determine that. Then there's the sunset provision. If you have looked at the case of Professor Apeje Etia versus the Attorney General in respect of the legality of the Imposition of Restrictions Act 2020, the Supreme Court noted that to the extent that that act did not have a sunset provision, it rendered the possible application of that act as a, if you like, it opened a Pandora's box where that act could be abused and could be found to be inconsistent with the principles of the Constitution. And so certain acts can have what is known as a sunset clause, where after the expiration of a set or after the doing of a certain event or after the expiration of time, the act would seem or would be deemed to not take effect any longer. In this instance, this is a form of automatic repeal, i.e., the act in itself has indicated that, say, for instance, after the death of a party, the act will stop, will not continue to be in application, or after Ghana, attains a certain debt ceiling, the act will not be in application, or after 10 years, the act will not be in application. And so there are certain statutes that include a sunset clause that automatically repeals the application of the statute after the happening of that sunset. And then to that extent, they will be deemed to have been an automatic repeal. So those are the three types, but generally the focus is on the two types in terms of express and implied repeals. But some statutes can also provide for sunset clauses by way of introduction. So let's go into express repeals then. Section 32, as I've highlighted, provides the effect of a repeal. It outlines that once a part of the law is declared as repealed in respect of that particular provision or the whole of the law, then the law is of no effect. But Section 34 effectively captures the effect of a repeal. So we'll be taking the provisions in Section 34 one after the other. Section 34.1. If somebody can please read Section 34.1 of your Interpretation Act, that is. Can anyone please read Section 34.1?
Okay, 34.1. Where an enactment repeals or revokes an enactment, the repeal or revocation shall not, except as in this section otherwise provided, A. Revive an enactment or a thing not in force or existing at the time at which the repeal or revocation takes place. B. Affect the previous operation of the enactment that is repealed or revoked, or anything duly done or suffered under the enactment.
Okay, Mr. Bidiakon, let's take it one after the other. So please read A again.
A. Revive an enactment or a thing not in force or existing at the time at which the repeal or revocation takes effect.
Okay, so section 34.1a is simply to the effect that, say for instance, we have 3 statutes. For the purposes of convenience, let's call them Act 100, Act 101, and Act 102. Now, Act 101 was repealed by Act 102. And now Act 103 has now repealed Act 102. What Section 34.1a is telling you is that despite the fact that Act 103 has now repealed Act 102, it would not automatically revive Act 100. I'll take it again. 3 enactments: Act 100, 101, and 102. Act 101 repealed and replaced Act 100. Sometime during the line, Act 102 has now repealed Act 101. You would think that if Act 102 has repealed Act 101, then 100 should now be deemed to have been revived or come into effect again, because the legislation that repealed 100 is now dead. And so 100 should be made to have been revived. It should be it should be allowed to be, resurrected from the dead. But what Section 34.1a is telling us is that if anything has been done by virtue of the repeal of 100 by 101, and there's a subsequent repeal of 101 by 102, that repeal cannot be deemed to revive anything done by 100. So you would find, for instance, that in the case of Kusia Pia against the National House of Chiefs, this should be the case in relation to when a particular chief was dispelled or removed by the government in 1958, and another person was installed paramount chief in his stead. Now, in 1966, the chief was restored to the stool by NLCD 112. However, in 76, he was removed from the stool and another person was restored to the stool by SMCD, which is the Supreme Military Council Decree 64, which also repealed NLCD 112. Now, in 79, that particular chief applied to the High Court for an order of mandamus to compel the National House of Chiefs to insert his name into the Register of Chiefs. He indicated that because SMCD had been repealed, SMCD 64 had been repealed, and LCD 112 had been revived. And so by virtue of that, he was supposed to have been reinstalled as a paramount chief by virtue of the provisions of NLCD 112, which had been revived by the repeal of SMCD 64. The court rejected this position, outlining the rule of law as set out in Section 34.1a of the Interpretation Act here, as we see it here, that to the extent that an act has repealed or revoked something, it does not revive anything that was done or any enactment that was not in force at the time at which the repeal or revocation took place. So simply this: if an act has been rendered unlawful by the repeal of a particular provision, and that new provision has been subsequently repealed, it does not legitimize that which was made unlawful by the previous act, which has now been the subject of repeal. That is the effect of section 34(1)(a). Is this clear? Any questions? Are we clear? Or can we proceed?
Yes, it's fine.
Okay. So, Mr. Bliaku, please read 34(1)(b).
34(1)(b) affect the previous operation of the enactment that is repealed or revoked, or anything duly done or suffered under the enactment.
Great. This one is fairly straightforward. If any act is done under the previous enactment, at the time the act was done, it was considered lawful because the enactment was in force and had full legal effect and had the full force of the law. And so to that extent, the repeal of that enactment does not invalidate anything that had been done or any liability that had been incurred or anything that had been suffered under the previous enactment. So the mere repeal, say for instance, we are looking at it in the context of Act 179, which was repealed and repealed by Act 992. The repeal of Act 179 did not invalidate the incorporation of companies that had been done prior to the coming into force of 992. They did not invalidate anything that had been done in relation to companies and the operation of companies in Ghana under Act 179. So the mere repeal or the act of repealing an enactment or a provision of an enactment at any point in time does not operate to invalidate anything that had been done at the time that the enactment was valid. You may see the case of Fatal and Minister for Interior, and also Kramo and Efie, very instructive on this score. Okay, please read C.
C. Affect a right, a privilege, an obligation, or a liability acquired, accrued, or incurred under the enactment that is repealed or revoked.
Similarly, similar explanation. So if you have acquired a right, privilege, obligation, any liability under the previous enactment, the mere ousting or the mere repealing of that enactment would not take away any liability that you has arisen. You may see the case of Isifu Kabore and Ghana Ports and Harbour Authority. In this case, the defendant argued that the right of the plaintiff to sue the previous two bodies, which was so what happened was the Ghana Ports Authority and Ghana Cargo Holding Company were merged into one entity known as the Ghana Ports and Harbour Authority under the GPHA law
That's why
1986. And
Serious why?
Victoria, can we proceed? I'm sorry, Victoria, do you have a question?
So let's proceed.
Okay. So, like I was saying,
Sorry.
like I was saying, the Ghana Ports Authority and Ghana Cargo Holding Company, which were two distinct entities, were merged into one. And they were merged by virtue of PNDC Law 160. And the defendants argued that the right of the plaintiff to sue the previous two bodies, which was the Ghana Ports Authority and Ghana Cargo Holding, for the value of goods which got missing while in custody of the two bodies, was lost by the promulgation of the new law that operated to merge the two entities. The court held that the mere passage of the law did not extinguish any obligations that the original defendants had to the plaintiff. And unless an enactment expressly diverts rights accrued in the former enactment, that right shall continue to be enjoyed. So it's important to note that when it comes to any rights, liabilities, or any duties that arise under an enactment, the mere repeal or revocation of that enactment does not automatically extinguish that liability or that right. And when that liability or that right has duly accrued, it will not lie in the mouth of a person to say that because the enactment has been repealed, the entitlement of that right automatically goes away as well. Please read section 34(1)d.
1D. Affect an offense committed against the enactment that is repealed or revoked, or a penalty or a forfeiture or a punishment incurred in respect of that offense.
So please start from the top again and then link it to 1D. So the beginning part of the enactment and then link it to 1D.
Where an enactment
Mhm.
repeals or revokes an enactment, the repeal or revocation shall not, except as in this section otherwise provided, affect an offense committed against the enactment that is repealed or revoked, or a penalty, or a forfeiture, or a punishment incurred in respect of that offense.
So 34(1)d is to the effect that if you commit an offense against an enactment and you incur the penalty or punishment, but the enactment is later repealed, the repeal does not affect the offense itself or the punishment incurred. So, for instance, there was a time where libel was criminal in this country, and somewhere in 2001, 2002, the criminal libel law was repealed. If you had been arrested, charged, convicted, sentenced, and you were serving your sentence, the repeal of the criminal libel law would not operate to prevent you from continuing to serve that sentence. That's the plain meaning of section 34(1)d. But there's a new dimension to 34(1)d, and there are two schools of thought. I would explain the two schools of thought, and then you may decide to take your position. What you have to do is to discuss the law, and the law is 34(1)d simply to the effect that once an enactment is repealed, any penalty, forfeiture, or punishment incurred in respect of that offense is not affected. And so a party is required to, if you like, continue to serve its tenure, or in terms of the punishment, or in terms of the forfeiture, in respect of the offense, even though the enactment has been repealed. Hear me out. In British Airways and Attorney General, and I'm sure you're very familiar with the facts of British Airways and Attorney General, while the trial was ongoing, there was a repeal of the law that had been the subject of the charge and investigation in the first place. The law was repealed. And so the defendants argued that to the extent that the law had been repealed, based on Article 1911, there was no offense for which they were being charged of, and simply that their continued prosecution was inconsistent with Article 1911 of the 92 Constitution. And so a classic understanding of British Airways and Attorney General is this: that if you have been arrested, you have been charged, the prosecution is ongoing, and there's a repeal of the enactment, the basis for which you were charged, and there was a prosecution ongoing, to the extent that you've not been convicted yet and sentenced, once the prosecution is still ongoing, then it will be inconsistent with the provisions of Article 1911 to have the proceeding continue, because there's no offense for which you are being charged with. Remember that the combined effect of 1905, 1901, 1911 is simply to the effect that before you charge somebody for a criminal offense, the offense must be in a written, or must be written, and the punishment for that stipulated. And so in British Airways, the argument made in British Airways was simply to the effect that because there had been a repeal of the legislation, there was no written offense for the purposes of which could allow a prosecution stand in light of Article 1911 in terms of the writtenness. So if you read the classical position in British Airways and Attorney General, and please read 34(1)(e). I need to make a point with that.
Affect an investigation, a legal proceeding, or a remedy in respect of a right, a privilege, an obligation, a liability, a penalty, a forfeiture, or a punishment. And the investigation, legal proceeding, or remedy may be instituted, continued, or enforced, and the penalty, forfeiture, or punishment may be imposed as if the enactment had not been repealed or revoked.
Great. So you would even find that 34(1)(e), in respect of the investigation, legal proceedings, or remedies, and privileges, obligations, and liabilities, had even been limited to civil matters. And so 34(1)(e), before the decision in Edmund Addo and the Republic, was viewed as being applicable only to civil matters, because on authority of British Airways and Attorney General, it would not apply to criminal offenses. And so any investigations, proceedings, and any legal remedy available, to the extent that the enactment had been repealed, would terminate on account of Article 1911. However, the Supreme Court has clarified in Edmund Addo and the Republic that by virtue of the provisions of the Interpretation Act and looking at the way in which an enactment can be phrased, if an enactment contains a savings provision, in relation to the continued prosecution of an action that began before the repeal process completed, then it goes without saying that that would satisfy the requirements of writtenness in respect of Article 19, or it being in writing in respect of Article 1911. However, even in the absence of this express provision, Section 34(1)(d) will be considered as a general savings provision, such that now, when an enactment is repealed in respect of, let's say, a criminal offense creating statute, when the enactment is repealed, it does not matter that a prosecution is ongoing at the time the enactment had been repealed. 34(1)(d) will operate as a general savings clause to save the application of the provision during the pendency of the prosecution and allow the prosecution to continue, even though the enactment has been repealed. So, for instance, in Edmund Addo and the Republic, this is the individual who had been, or who is alleged to have had unlawful carnal knowledge of a minor and recorded her and then leaked her videos onto the internet. And then he was arrested and charged with 2 offenses, or 3, I think. One was defilement, and the other one related to unlawful display of a minor on the internet or something. I've forgotten the particular charge. But that particular offense was provided for by the Electronic Transactions Act. That particular provision was repealed by the Cyber Security Act, which came into force recently. And so when the repeal occurred, an application was made by counsel for the accused person, urging the court to strike off that offense in relation to the display of the videos on the internet, because that particular provision in the Electronic Transactions Act, or Electronic Communications Act, sorry, had been repealed by the Cyber Security Act. The Supreme Court, of course, when it went to the Court of Appeal, the High Court threw it out. Court of Appeal disagreed with counsel for the accused, and Supreme Court essentially affirmed the position of the Court of Appeal by indicating that Section 34(1)(d) operates as a general savings clause for all instances where an enactment has been repealed and there's a prosecution ongoing during the pendency of the repeal of that enactment. And that 34(1)(d) and the provisions of Section 34 are different from CA4. which was the act in force at the time British Airways and Attorney General was decided. And so if Edmund Addo and the Republic was decided under CA4, they would have reached the same conclusion in British Airways and Attorney General. But the position of the Supreme Court is that the phraseology used in 34(1)(d) indicates that the offense committed against the enactment is not whittled away simply on account of the repeal of the enactment, and that 34(1)(d) operates as an express savings provision, and that when the legislature has not expressly indicated in that act that they are taking away everything that has happened in respect of the offense committed at the time, then 34(1)(d) will operate to save the provision to allow its application until the conclusion of the prosecution of the party involved. So the said individual is still being tried under the old enactment, even though it has been repealed. Do you understand the position and adopted by the Supreme Court? This is not a popular position. Some people disagree with the fact that the Supreme Court took this position, and that is well within their rights to disagree. But the position of the law is this: that 34(1)(d) operates as a general savings provision, and so to that extent, the repeal of an enactment, unless expressly indicated in the repeal or the legislation that is repealing that enactment, would not suspend the conduct of a prosecution in respect of that offense. Are you clear? And that's, yes, I need to add that, and that for the purpose of writtenness, which of it being in writing, which is expressed by Article 1911 of the Constitution, that will be fulfilled by the saving nature of 34(1)(d). And so it is not correct to state that to the extent that the enactment has been repealed, there will be no offense in writing under which the prosecution can take place consistently with Article 19 of the Constitution. If we are looking for writing, 34(1)(d) will operate to save that provision, and that would be sufficient in allowing us to determine that there has been a fulfillment of the requirements of writing in accordance with the 92 Constitution. Please, any questions? Hello.
Hello, Sina.
Yes.
Yes, for purposes of maybe practice and the rest. So the 34(1)(e), I see a kind of savings here. If you look at the last phrase, as if the enactment had not been repealed or revoked. I think that is the basis the Supreme Court capitalized on to give that judgment. So we can say that because the Interpretation Act is more or less superior than case law, then we can ascribe to this. Under what other external circumstances can we find maybe an enactment or a law vitiating or trying to challenge or having a tangle with the 34(1)(e)?
I don't quite grasp the question. Can you please come again?
What I'm saying is that the 34(1)(e) was what the Supreme Court used in the case of Edmund Addo's case. What other arguments will challenge the 1E?
So the primary arguments that the those who oppose this position taken by the Supreme Court is that, remember, 1911 is to the effect that the offense must be in writing and the punishment for it prescribed for. The repeal of an enactment effectively removes it from our statute books. When you repeal an enactment that is not in writing, it has no effect on our statute books. And so the position they take is that that singular act of repeal, especially when there has not been an express saving of that provision by the legislature, suggests that it does not comply with the requirement of writing within the contemplation of Article 1911. That's the position that they take. And so based on that understanding in British Airways and Attorney General, that is why the position had been that 34(1)(e) was inapplicable to criminal cases by virtue of Article 11 of the 1992 Constitution. However, as we have seen in Edmond Addo and the Republic, because of the if you like, the general savings nature of 1D and 1E, it now extends to criminal trials. And if there's any criminal investigation or legal proceeding that has been commenced and the act is subsequently repealed, it would continue. It would not terminate on account of the repeal of the enactment. And further, that if you are looking for the requirements for writing, 34(1)(d), 34(1)(e) read together will operate to preserve the enactment for the time being, if you like, in a transitional manner, and still satisfy the requirements of Article 1911 of the Constitution. And so to that effect, the critics would not have any basis to stand on. And that if British Airways were decided using Act 792, the Supreme Court then would have come to a different conclusion, because in the view of Justice Asiedu, who wrote the majority decision, or in fact, it was a unanimous decision, I think, I'm not too sure. In the view of Justice Asiedu, Section 8 of CA4, it is not in pari materia, or is not the same as Section 34 of Act 792.
I think I'm fine. I'm okay.
Okay. Please, any other questions? Can we proceed?
Sorry, hello. Hello.
Yes, go ahead. Enes, go
So
ahead.
please, so just to be clear, you are saying that, so in the British Airway case, they stated that if the act is repealed, once it's repealed, any ongoing investigation and prosecution would cease.
Yes.
Okay. And then that position was only applicable for civil cases, but then now the Edmond Addo has changed the law on all those ones.
So I'm saying 34, previously, the previous understanding was that 34(1)(e) was applicable for civil cases.
Okay.
And because there's no requirement for writing and all of that fanciful thing housed in Article 1911 in respect of civil matters, it only applies to criminal matters. And so based on the understanding of British Airways, in terms of investigations or legal proceedings or claims for remedies, it didn't apply to criminal proceedings. But now, based on understanding set out in Edmond Addo and the Republic, is not. It appears that the position has now been changed to suggest that, based on the general savings nature of 34 and the way in which 792 has been couched, we still satisfy 1911 in terms of writing. So why not?
All right. Thank you very much.
Any other questions? Great. So, I mean, the debate is still out there as to the correctness or otherwise of the position adopted by the Supreme Court. They are very strong critics. I agree with the Supreme Court. I think the Supreme Court was right, but you are entitled to disagree with me and disagree with the Supreme Court. What you cannot do is to move away from the position of the law, which has been espoused in the case, until there's another decision that departs from Addo and the Republic. In your discussion of 34, you have to apply Addo and the Republic. Great. Moving on. So we've discussed 34(1)(d) and 34(1)(e). I want you to skip to 35(2)(e) and for us to discuss Obenjevi a bit, which has also been the subject of a little discussion and debate. So please read section 35(2)(e).
35(2)(e). Where an enactment repeals or revokes an enactment in this subsection and in subsection 3, referred to as the old enactment, and substitutes by way of amendment, revision, or consolidation with any other enactment, where a penalty, a forfeiture, or a punishment is reduced or mitigated by a provision of the enactment so substituted, the penalty, forfeiture, or punishment, if imposed or awarded after the repeal or revocation, shall be reduced or mitigated accordingly.
Mr. Briaku, please read it again because I want to set the grounds under which people disagree with the ruling in Obenjebi.
Okay, so 35(2)(e). I'm reading from the two first. Where an enactment repeals or revokes an enactment in this subsection and in subsection 3, referred to as the old enactment, and substitutes by way of amendment, revision, or consolidation with any other enactment, where a penalty, a forfeiture, or a punishment is reduced or mitigated by a provision of the enactment so substituted, the penalty, forfeiture, or punishment, if imposed or awarded after the repeal or revocation, shall be reduced or mitigated accordingly. Hello?
Yes, thank you, Mr. Briaku. Please give me 1 second. Let me pull this up. So 35 generally relates to the effect of a repeal of an enactment and the revocation or reenactment of another enactment, and generally the effect when that has occurred. Specifically in E, it outlines that where a penalty or forfeiture or a punishment is reduced or mitigated by a provision of that enactment so substituted, the penalty, forfeiture, or punishment, if imposed or awarded after the repeal, shall be reduced or mitigated accordingly. So you have been convicted, you are yet to be sentenced of an offense. Before the sentencing takes place, the maximum penalty is reduced from, say, for instance, 15 years to 10 years. Even though your prosecution has concluded before the coming into force of the repeal, you are still, or the revision of the enactment, you are still entitled to benefit from the reduced sentence. That's the position in 35(2)(e). And this has constitutional backing. However, so in Obenjebi and the Republic, what occurred was this is a person who had been convicted and was appealing the process, but his appeal had stalled. And so he had been convicted of an offense, and the penalty for that offense has subsequently been reduced from, I think, a longer sentence. I've forgotten the particular sentence, but a longer sentence to a shorter sentence. And he filed an appeal. And when he filed the appeal, the basis of his appeal was that he hoped to have his sentence commuted on the account of the fact that there had been a reduction of the sentence in accordance with section 35(2)(e) of the Interpretation Act. The Supreme Court made this point that when a person has been arrested, has been convicted, has been sentenced, or so arrested and convicted, has been sentenced, and the person is appealing the sentence, if there has been an amendment or a repeal, a revocation, a revision as to the extent to which the penalty should be, the person is entitled to enjoy the new sentencing regime. I'll explain. What the Supreme Court said essentially was that, robbery, the penalty for robbery in terms of the number of reduced. So say, for instance, for the purposes of this discussion, say, for instance, the punishment for stealing was 25 years. Kwame was arrested, prosecuted, convicted for stealing for 25 years. And then he's appealing. And when he appeals, he's appealing the sentence. If at the time of his appeal, the sentence has been reduced to 10 years, even though he was convicted at a time where the sentence was 25 years, he is now entitled to benefit from the 10 years if his appeal is successful. And so what the Supreme Court noted in Obinjebi against the Republic or versus the Republic was that because an appeal is by way of rehearing, a party who has been previously convicted of an offense and is appealing the process is entitled to benefit from the new sentencing regime at the time of the appeal, because the appeal is by way of rehearing. And so if the appeal is by way of rehearing, the court that is seized with the appeal at that time must apply the law in force at the time of hearing the appeal, not at the time of the commission of the offense. And so subsequently, if there's any benefit to be derived by virtue of being if there's any benefit to be derived by virtue of being by going on appeal at that particular point in time, then the appellant is entitled to benefit from that. Of course, the primacy with that type of argument is that a person may be convicted 10 years, maybe serving his sentence, and then a repeal of that enactment under which he was convicted may happen. Then he quickly files an appeal to ensure that he can benefit from the new sentencing regime. That effectively defeats the very purpose and intent under which this enactment was spelled out. And so Obenjebi has also been the subject of a bit of criticism as to the fact that it opens the floodgates for all manner of persons to appeal offenses in respect of what they've been convicted after the repeal of the enactment under which they were convicted. However, the position of Obenjebi indicates that it is immaterial if the person has been sentenced and the person has been convicted. If the person is appealing his sentence at the time of rehearing, which is what the effect of an appeal is, the appellate court must use the substantive law in hearing the matter. And what the substantive law is what will help determine the penalty that should be prescribed at any point in time. Please, any questions?
So, good afternoon.
Excellent.
Please, does it then mean that irrespective of whether the substantive law, the punishment has increased or decreased, so far as you are appealing, the court is going to apply the law as it is now and not as it was when you were convicted?
Or if it's an increment, the Constitution prevents and the Interpretation Act does not allow if it's an increment. But if it has been mitigated or reduced, then you're entitled to benefit from the reduction. So that's the position. If it's an increment, they cannot apply the increased offense to you. But if it's a reduction, you're entitled to benefit from the reduction.
Oh, okay. So then the Obinjebi has to do with only reduction. So
Yes.
where you were convicted and it was a higher sentence,
Yes.
but on appeal, that particular law has been repealed and a new one has reduced the sentence, the court will have to use the new one to apply to your case.
Precisely.
Thank you.
Any other questions, please? Okay, so read Obenjebi, read Edmonado and the Republic, two very interesting decisions of the Supreme Court. So that is it for express repeals. Let's go to implied repeals. Now, a repeal can also be made impliedly. That is, there can be a situation where there's no express revocation of the enactment in a statute, but the law, by virtue of the application of certain principles, would cause an implied repeal. As you are aware, based on Article 2.1, if there's any provision of law that is inconsistent with the Constitution, 92, to the extent of its inconsistency, it will be struck out as null and void. That is a general principle that we must be aware of. And the second way in which you must look at it is in terms of the hierarchy of laws. So if there's subsidiary legislation, there's an LI that is inconsistent with an act of parliament, then said LI would be null and void to the extent of its inconsistency with the act of parliament or the constitution. So in terms of the hierarchy of laws as established by Article 11, subsidiary legislation, of course, are subsidiary to substantive legislation, and to the extent that they're inconsistent with the provisions of legislation, they should be struck out as null and void. Now, for our purposes, the two main ways in which an implied repeal can also take effect is through the application of the maxim of legis posterioris prioris contraris abrogant, which is simply to the effect that latter laws abrogate earlier contrary laws. And so, when a law is passed later in time to an earlier law, to the law that is later in time, to the extent of its inconsistency with earlier law, will be deemed to have impliedly repealed the earlier one. And so you may look at the case of Coles Motors and Checkpoint and Nankoja and Imbagi, where the court considered various contrasting positions of the law. And the court found that where a statute or the provisions of a statute are inconsistent or repugnant with the provisions of an earlier statute, the two cannot come together. And so it will be deemed that the legislature or the lawmaker intended that the newer one repeals and, if you like, vitiates the application of the older one. So it's fairly straightforward. A law passed 1990, a law passed 2005. They are inconsistent with each other. That inconsistency can be resolved using the legis posterioris rule in terms of the law that is later in time. Then there's the generalia specialibus rule, which relates to the fact that in terms of looking at legislation, when there's a special rule made for a specific item or a specific application of the law, as opposed to the general application of the law. For example, there's a general right of appeal for a party who has a cause of action in the High Court. You are entitled as of right to appeal to the Court of Appeal, and you're also entitled as of right in terms of a right of a further appeal to the Supreme Court. One second. Similarly, on the contrary, when it comes to parliamentary election disputes, the Supreme Court has clarified, and in parliamentary elections for Wulensi, Zakaria and Yemakan, that the right of further appeal to the Supreme Court does not arise in respect of parliamentary election petitions. And so in that case, the Supreme Court looked at Article 99(1) and saw it as a special provision that deals with matters that arises when it comes to parliamentary election petitions. And so when we are looking at legislation, and the legislation is there are two sets of legislation that are inconsistent with each other, will defer to the special one if a special provision has been made in respect of that matter as one that impliedly repeals the general application of the law to that specific matter. So for instance, in Boni and others against GPHA, the issue that arose was the limitations of actions in respect of when a person could bring an action against the GPHA. What the applicants or the plaintiffs in that case were attempting to do was to bring an action outside the 12-month period. And they argued that under the limitation decree NRCD 54, they were entitled to bring the action because the limitation period had not expired. But the GPHA law at the time outlined that if you wanted to bring an action against the GPHA in respect of the claiming which they were claiming, you needed to have brought that within 12 months on the occurrence of the event. And so the court applied the special law in relation to that particular set of facts and held that to that extent, when it comes to limitations, we'll apply the limitation decree. But if there's a special law in relation, or there's a special provision in relation to limitations that will apply in respect of GPHA, then the court will apply the special limitation. So those are the two instances under which there can be an implied repeal of a provision of law, and it is simply to the effect that when there's an inconsistency with two or more provisions of the law, you can either resolve it using the generalia specialibus provision. This is when they are all on the same level. If they're on different level, we resolve using hierarchy of laws. But if they're on the same level, then we resolve using either the generalia specialibus rule or we use the leges posterioris rule. Please, any questions? Great. So that will be it for repeals. And we can move to retrospective legislation. But before we go to retrospective legislation, is there a difference between retrospectivity and retroactivity? Is there a difference? Does anybody have any ideas you want to share? None? Okay, you may look into it. Retrospective legislation. Now, a statute is retrospective in nature, a vested right acquired under an existing law, or it operates to impose new obligations that were not existing under the existing law in respect of events already passed. And so we see that outlined in the case of Aaron Basmara as to the effect of or the definition for retrospective legislation. Generally, the Constitution proscribes the use or the application of retrospective legislation. There's a general bar on retrospective legislation. If anybody has their constitution, please read Article 107. Article 107, please.
Article 107. Parliament shall have no power to pass any law. A. To alter the decision or judgment of any court as between the parties subject to that decision or judgment. Or B. Which operates retrospectively to impose any limitations on or to adversely affect the personal rights and liberties of any person, or to impose a burden, obligation, or liability on any person, except in the case of a law enacted under Articles 178 to 182 of this Constitution.
Great. So as a general rule, all statutes must be prospective in application. They cannot go back in time to alter or create new obligations for parties. And they can't also go back in time to take away any vested rights or impair and affect those vested rights. So, for instance, in the case of Patu Styles and Amo Lamte, Justice Taylor announced that prima facie enactments that repeal or revoke other enactments are prospective and they are not retrospective in their operation, and thus they only embrace prospective rights. And so this general common law restriction on the application of retrospective legislation is what has found expression in Article 107 of the Constitution, which provides that Parliament shall have no power to pass any law which operates retroactively to impose limitations on or adversely affects personal rights and liberties of any person, or proceed to impose a burden, obligation, or liability on any person, except in the case of a law enacted under Articles 178 to 182 of the Constitution. When is a statute deemed to be retrospective? Now, a statute will be said to be retrospective if it takes away or impairs a vested right acquired under existing laws, or creates a new obligation, or imposes a new duty, or attaches a new disability in respect of events already passed. And even though we have outlined that statutes must be of prospective application, there are exceptions to the use of retrospective legislation. Parliament still has the power to pass retrospective law. The only bar on that power of Parliament to pass retrospective law is if the law imposes limitations or adversely affects the personal rights and liberties of any person, or imposes a burden, obligation, or liability on a person retrospectively. What this means is that if Parliament passes a law that is of retrospective effect, but imposes a benefit, imposes a right, and does not adversely affect a right or liberty of a person, that law will be valid within the contemplation of the 1992 Constitution. I'm saying that the limitation on Parliament's power to pass a retrospective legislation is not an absolutely cannot do. It is one that parliaments can do, but subject to certain limitations. And the limitations have been spelled out in Article 107B. It is clear to the effect that if Parliament passes a law that imposes a limitation or adversely affects a personal right or the personal liberties of any person, retrospectively, or it proceeds to impose a burden on any person, then that law will be deemed to be inconsistent with the 1992 Constitution and will be null and void. However, what I'm suggesting to you is that if the law is beneficial to a party, does not impose a burden but imposes a benefit, and does not occasion a liability but rather provides a right and operates retrospectively, that law will be valid within the contemplation of Article 107. Please, is this clear?
I think that's again.
I'm saying that 107 establishes the marker. It establishes the bounds under which retrospective legislation would be acceptable or would not be accepted. So the point needs to be made that there's no express bar on retrospective legislation. The only time we forbid retrospective legislation is when it is retroactive in effect. And legislation is said to be retroactive in effect if it imposes limitation, it adversely affects the personal rights and liberties of any person, or imposes a burden, obligation, or liability on any person retrospectively. So if Parliament enacts a law which would apply retrospectively to impose a burden on you, so when we say apply retrospectively, it means it happens to events already passed. So you incorporated a company. At the time of incorporation, we said the filing fees was 270 cedis. Parliament passes a new Companies Act or a new Fees and Charges Act and says that now the incorporation of companies is 700 cedis. It will not be proper for Parliament to require you to now pay 700 to go back in time and pay 700 cedis to validate your incorporation of the company, when at the time of incorporation the amount was 270 cedis. In that instance, what Parliament would have done would have allowed or would have been to impose an obligation or burden on you retrospectively, because that burden did not exist at the time you were undertaking the event. And we are saying that that is what is unlawful. However, the law does not prevent Parliament from passing a law which is of retrospective effect if the law confers a benefit, does not impose a burden or obligation, but rather confers a right. In that instance, that would not be a breach of Article 107B of the 92 Constitution. I saw somebody's hand up. Please proceed to ask your question. But Elizabeth, do you get it now?
Yes, I understand perfectly that if it's conferring a benefit, then it can apply retrospectively. But if it's going to affect you such that there'll be a liability or a burden, then the law forbids that. And that's
Okay,
what it
Mr.
is.
Great, thank you. Mr. Yamson, your hand was up, I suspect. Or any other questions, any clarification on this?
It's okay. It's okay. I wanted to ask for clarification, but I'm done. It's okay. Your further explanation clarified it. Thank
Okay,
you.
you're welcome. Any other questions, please? Great. So that's the first exception to the prospective application of law, that laws may be applied retrospectively as long as they do not operate retroactively, such that they are imposing burdens, obligations, or liabilities on people. So, for example, you may recall that Parliament passed an amendment to the Criminal Offences Act, which reduced the sentence for robbery from life to a term of imprisonment not exceeding 10 years. This was also one of the things that came up in Obenjibi, right? And because the reduction in sentence did not adversely affect the personal rights and liberties of any persons, nor did it impose any burden, obligation, or liability on any person respectively. So in criminal statutes, when Parliament passes a law that reduces the penalty, then that could be to the benefit of persons that are going through the process. But if it operates to increase the liability, then that would be inconsistent with the provisions in Article 107, and the persons who have committed the offense at the time would not be tried using the newer or harsher penalty in that respect. There are also a number of other exceptions. So we've mentioned the first exception. The second exception I want you to note is also present in Article 107B itself. It says that when it comes to laws relating to 178 and 182, it can be of retrospective application. So financial laws, that is why generally the budget can be passed and then, it can take effect on a certain date retrospectively, because the Constitution allows generally that when it comes to financial laws within the contemplation of 178 and 182, it can be applied retrospectively. Apart from that, the common law also gives us other exceptions to the retrospective application of law. The first one is when it is a procedural enactment. If the law is procedural in nature, so the case of Finiku and John Tay outlined the general exceptions, and we'll take them one after the other. And so the first one we'll look at is if it relates to procedural enactment. Who can give me an example of a procedural enactment? An enactment that relates to procedure.
CI 47.
CI 47.
At 30.
CI 47 at 30. The Court of Appeal rules, the Supreme Court rules. These are all procedural enactments that spell out the procedure with which something must be done. Even though there's a general proscription on or there's a general prohibition on retrospective legislation, a retroactive or retrospective application of procedural statutes is permitted by the court. The position of the law is that there's no vested right in procedure, and so an enactment or a procedural enactment can be applied retrospectively to change the application of something that has already been done at the time of the enactment. You may see the case of Konda and Dompre. Konda is spelled Konda, and Dompre is spelled Dompre. Procedural changes in law have both prospective and retroactive effect on all pending actions. The point must be noted that any procedural change in the law, so any procedural change that you find in CI 47 can have both prospective and retroactive or retrospective effect on all pending actions. There's no vested right in procedure. Similarly, when it comes to evidentiary matters, matters relating to evidence, they are also deemed to have, or they may also be deemed to have retrospective effect. Fenuku and John Tay also outlines this. And so when it relates to the rules relating to evidence, the law or the general position is that it can also have retrospective effect. The third exception also relates to laws which are declaratory in effect. Laws which are declaratory in effect, they're also deemed to have retrospective application. The fourth is laws that are revised and consolidated, like the consolidated laws of Ghana, are also deemed to have retrospective effect. We've already discussed the exception on in terms of the financial laws. Any questions? Great. So I want us to look at a question in relation to repeals and retrospective legislation and see how we approach it. And then that would have been a useful exercise of our time. So just give me a minute or two to find the question, please. Please, can you see my screen?
Yes.
Yes.
Yes,
Yes, please.
All right, Mr. Bediako, can you please read for us?
City Capital Airlines Limited was charged with the offense of permitting another person to carry spirituous or fermented liquor on board the aircraft, contrary to Section 1200 of the Criminal Offences Act 1960, Act 29. The facts presented in court were that Eric Norty, a cabin crew member of City Capital Airlines Limited, on 4th June 2015 took into aircraft AB-101 scheduled for Kotoka International Airport to JFK International Airport in the United States of America 10 bottles of fermented liquor and a bottle of spirituous liquor. Even though Section 1200 of Act 29 makes it an offense for an airline to permit a person to carry spirituous or fermented liquor on board, the officers of City Capital Airlines permitted Eric Norty to carry the 10 bottles of fermented liquor and the bottle of spirituous liquor into aircraft AB-101. City Capital Airlines was registered under the Companies Act 1963, Act 179, Section 2000 of the Companies Act provides that any company registered under the Act which permits a person to carry liquor of any form into an aircraft shall have its registration revoked. City Capital Airlines Limited was arraigned before the High Court on 10th December 2015 on a charge of permitting a person to carry spirituous or fermented liquor on board an aircraft, contrary to Section 1200 of Act 29. The airline pleaded not guilty to the offense, and the case was adjourned to 1st April 2016 for hearing. On 10th December 2016, the Registrar of Companies also filed a petition in the High Court under Section 2000 of the Companies Act to revoke the registration of the airline. In the course of hearing the criminal suit, Section 1200 of Act 29 was repealed, and the repealing enactment did not save the repealed Section 1200. On the following day, Section 200 of the Companies Act was also repealed without any savings provision. You are a junior member of Lahibi Legal Excellence Firm, which is representing City Capital Airlines Limited in both suits. Write an opinion as to the sustainability or otherwise of both suits.
What are we thinking? What's the from the top? What's the area of law?
Repeals and revocations.
What's the area of law? Any ideas? This is fairly straightforward. What is the area of law?
Hello.
Yes, go ahead.
Interpretation of statutes, specifically the effect of repeal of laws, of legislation.
Okay. Anybody else? One last attempt. One last attempt, and then we can proceed. Okay. So the area of law is statutory interpretation with specific reference to repeals and retrospective legislation. You have to remember that repeals and retrospective legislation is an offshoot of statutory interpretation. So your area of law must start from the general before you go to the specific. So to be appropriate to couch it as statutory interpretation with specific reference to repeals and retrospective legislation. What do we think are the issues? I hope you can see. I'm putting it up here so you can read it again. What do you think are the issues? There are two issues really. What do you think they are? No ideas. Okay, so let me ask this question. Let's even forget the issues. Based on what we've discussed today and based on the facts in this case, what do we think would be the appropriate way to resolve this? The facts of this case are similar to British Airways and Attorney General, and it raises two distinct issues. The first issue is whether or not the criminal action against City Capital Airlines Limited will succeed. And the second one is whether or not the petition to revoke the registration of City Capital Airlines will succeed. So the first one relates to a criminal action, and the second one is a civil action. The first one is, as it were, a criminal action against them for the export of spirituous liquor. And the second one is a petition to revoke their registration on account of doing that. So, having set out the issues for you, I just want a general overview or a general view on how you think the question should be resolved. In terms of your general discussion of law, when you're answering a question of this nature, what you should first begin with is, I'm sure by this time you're conversant as to how to answer interpretation questions. From your area of the area of law, and then you go through the issues, and then you do a general discussion of law. A general discussion of law requires that you discuss everything you know in respect of that particular area of law that you have outlined. So this is a good opportunity for you to spell out your entire knowledge on repeals and retrospective legislation. In this question, it relates specifically to repeals. And so your general discussion of law should focus heavily on repeals and not necessarily retrospective legislation. I mean, you will discuss retrospective legislation, what it is briefly, and put in there your almost your Patu Styles and Amolamte, Ubuntu and Kendaran, Basmara, and Fenoko and John Tay in respect of retrospective application of law, Article 107 generally. But the focus here really is on 32, 34, 1911, 1905, British Airways Attorney General, and Edmund Ado against the Republic in respect of the understanding of repeals. And so you have to discuss repeals generally, go through the provisions of Section 32 and 34 of Act 796, discuss everything there thoroughly before you now zone in respect of, as it were, the discussion the Supreme Court outlined in British Airways and Edmonado against the Republic. But I guess my question to you is, having set out all of this and basically answered the question for you, what would your conclusion be?
Yes, sir.
Go ahead, sir.
Yeah, so in concluding, can you pick on the two extreme situations, the JB one and the Edmond Addo one, and regarding how the Supreme Court has upheld the 36(1)(e) as against what had transpired in the British Airways case. Do you have to pan along the two lines of discussion and probably choose your position, because the current position of the law is what the Supreme Court has said? Can it be said, can you be said to do something of that nature?
Yes, essentially. In fact, this question was set at a time where British Airways and Attorney General was the position of the law. This is 2017. And so, in a question of this nature, it will be imperative to discuss both positions, British Airways and Edmond Addo, and then conclude using Edmond Addo. So, if we are going to conclude using Edmond Addo, how do we resolve the matters? What the issues that we've raised? The question literally said an opinion as to the sustainability or otherwise of both suits. So, in our view, in respect of both the attempts to, if you like, revoke the registration of the company and arraign them in terms of a criminal matter, what would be the position of the court? Especially in light of the express statements made here that both provisions were repealed without any saving provisions. What is the effect of that? Like, what does that add to the general nature of the discussion we're having?
So actually, I'm thinking that then Section 34 will then come in to say that although there were no express provisions that saved those previous laws, Section 34 will come in and then make, make the trial continue, irrespective of the fact that the substantive law which brought up the suit has been repealed. So the one who carried the spirituals or the fermented drink to the cabin, although the law has been repealed, Section 34 will come in to see relying on Edmond Addo and not British Airways.
Okay. Does anybody else have a view? So there's a case that explains section 34(1)(e) in relation to civil matters. I'll look for it and let you have it. And then you can address the question of whether in light of Edmond Addo, that was also a Supreme Court decision, really. Peduce JSC. I don't know if it's, I'll look for the case for you. But it outlined really the position when it comes to civil matters. And so you'll be able to determine whether in light of Edmond Addo, even in civil matters, this is also applicable. Great. Any other questions, please? I mean, any other contributions to this? Okay, let me look for one other question and then we can. 1 second, please. Unfortunately, I'm not getting a question that um, directly addresses this, but hopefully I would look for one, and maybe by our next session we should be able to discuss that before we proceed. Please, any other questions? Any pending questions in relation to what we've discussed today? Great. So today we've attempted to look at repeals and retrospective legislation, which is a if you like, an element of statutory interpretation, and we've outlined what repeals are, what the effect of a repeal is, and what the Supreme Court's guidance in relation to the provisions of repeals under the Interpretation Act are. And then we've also looked at retrospective legislation, what the effect of retrospective legislation is, and what the exceptions there to, and the instances that a retrospective application of the law would be permitted. And so that has formed the fulcrum of our discussion today. And I hope that you found it useful. In the absence of any questions, we may bring this to an end, and then I guess I'll see you next time.
Thank you, Tina. Yeah, I can speak for.
All right, thank you.
Thank you.
Thank you.
Thank you.
Oh, you can't also look at Papa.